But presently, three of the kind of offenses identified, the 10 offenses identified in the bill, require material harm to competition or something like those terms. I need to look up the precise language as an element of the harm. The other 7 don't. They describe conduct. So it just lays out, if you do this, that's prohibited. But then in terms of defenses, those last 7 allow what's characterized as an affirmative defense of showing that there isn't material harm to competition or something like that as a result. So that's kind of the sense in which you're I think right to say that you can look at this as shifting burdens. Like in some sense, the burden is on the plaintiff to prove harm to competition, whatever that means here, for the first 3, and it's the burden is kind of on the defendant to prove it doesn't exist for the last 7, which you can think of as saying, well, these categories are per se illegal for the last 7. But the definition of an affirmative defense is even if it satisfies that, then the affirmative defense can be raised as a defense. So that's to say, well, yeah, it's illegal, but if you can prove it doesn't harm competition, whatever that means, then you can get an exception. The thing kind of to note there, and one thing that the ABA comment kind of really presses on is requiring market power, substantial market power, and harm to a competitive process as a way that current antitrust focuses on a harm. So it identifies a specific type of harm using those elements. When a plaintiff proves that substantial market power exists, there's going to be harm to the competitive process as a result of certain conduct, the plaintiff has now shown here's the harm in the world. And that makes the defense clear. You attempt to prove, if you're the defendant, that one of those showings was wrong. There wouldn't be that harm in the world. The second 7 offenses under this bill are curious in that it's not really clear what the harm is. What's prohibited is conduct. Even if the conduct has no effect, it's made illegal unless an affirmative defense is raised. And the affirmative defense requires that it doesn't harm competition, but harm competition is undefined. So it becomes kind of this question of, well, you have to prove that harm doesn't result, but it's not ever really made clear what the harm is in the first place. So I'm not 100% sure how you defend that presently. This is not a fault per se. It's just a question in my mind. I'm not really sure if I was sitting down and trying to draft out my affirmative defense for those last 7, where I bear the burden of showing that competition isn't harmed. I don't know what I would identify there as a factor in the world that shows that.